Hi, everybody. A very warm welcome to thorough newspaper analysis for the 9th of April 2024. Now, let's quickly proceed and have a look at the pointers of discussion for today. So, first of all, for the editorial segment, we have an Indian Express article with the title, The Citizens' Climate Rights. This is a very important article, students. Please make notes if possible, and I'll tell you why. See, recently we did an editorial article on how there have been a couple of efforts made for conservation of great Indian bustard, and the matter was before the Supreme Court. This article, I believe, was covered last week, in the last week of March. So the Supreme Court made certain observations with respect to, how can we balance the conflicting interest of, on the one hand, preserving the great Indian bustard, and on the other hand, the government's projects for production of renewable energy. Now, this particular judgment, it was delivered by the three-judge bench of the Supreme Court on 21st of March, but it was made public on Saturday. And when that happened, one observation of the Supreme Court has now come to the forefront. What is that observation? That, in fact, is the point of discussion in this article. And I'll tell you why that observation is very important. So what Supreme Court has essentially said is that people have a right to be free from the adverse impact of climate change. And this right, it should be recognized by Articles 14 and 21 of the Indian Constitution. So what essentially has happened here? See, I'm sure all of us, we know that over the past so many years, the ambit of Article 21 has been extended by these constitution law courts, let's say Supreme Court, by inducting a series of rights. For example, the right to have access to free and clean air, right to have access to shelter for slum dwellers, and all of these, XYZ. These are a couple of rights which are included in Article 21. So similarly, in this particular case, the Supreme Court made an observation that we have a right to be free from the impact, which is adverse impact of climate change, and that right should be recognized by Articles 14 and 21 of the Indian Constitution. So secondly, we talk about the news updates, and this is going to be followed by the legal news for the day. So let's quickly see the context of this article. The Supreme Court has ruled that people have a right to be free from adverse effects of climate change, which should be recognized by Article 14 and 21 of the Indian Constitution. So this is the Supreme Court's observation. Now, a question might come to your mind as to, when and where was this observation made? So the judgment by a three-judge bench, including and headed by Honorable Chief Justice of India, D.Y. Chandrachud, and Honorable Justices J.B. Pardiwala and Manoj Misra, it was delivered on 21st of March in a case relating to the conservation of critically endangered great Indian bustard. We've already done an extended, detailed article on this particular case, but today also I am going to rope in, relevant facts which are necessary for understanding this particular article. This judgment, it was made public on Saturday. The bench, it noted that the intersection of climate change and of human rights, it has been put into sharp focus in the recent years, underscoring, or to say, highlighting the imperative for states to address climate impacts through the lens of rights. Now, let's see what is the case before the Supreme Court, and then we see what the Supreme Court has said and how the Supreme Court has interpreted Article 21 earlier. See, the Apex Court's ruling, it came in a writ petition which was filed by a retired government official. He sought protection of great Indian bustard and lesser florican. This is essentially also a bird in the family of bustards, but it is the smallest in the bustard family. So the petitioner, he sought protection of the great Indian bustard and lesser florican, which are on the verge of extinction. Now, if you remember, in the earlier article, we discussed that the prominent habitat for the great Indian bustard is where? In the state of Rajasthan, the Thar desert portion specifically, and the state of Gujarat, particularly the Kutch district. Now, in these places, recently, a couple of renewable energy projects they have been installed. So, as a result, a lot of overhead transmission power lines have been erected and installed in these areas. So what happens is these great Indian bustard, they are very heavier in weight, and these birds, they do not have they do not have a sight which enable them to see far off distant objects, so they are unable to see distant objects, and as a result they end up colliding with these power lines, and often fatalities are caused to these birds because of this colliding itself when the power lines are extremely huge, and if not that, then by electrocution. So this was the prominent reason for fatalities being caused to these birds. So the plea it sought, among other things, framing and implementation of emergency response plan for the protection and recovery of the great Indian bustard, including directions for installation of bird diverters. We saw a picture of how a bird diverter looks like. So this is essentially this is suppose a power line, and here a wheel shaped structure is attached, which is called a bird diverter. It has different color patterns which is helpful for reflecting lights, enabling these birds to see far off objects or these transmission lines. So this plea it sought the issuance of directions for installation of these bird diverters. It also sought an embargo on sanction of new projects and renewal of lease for existing projects, and dismantling of overhead power lines, wind turbines, and solar panels in and around critical habitat for these birds. In the hearing, which was held in March, the Supreme Court was considering an appeal for the modification of its April 19, 2021 order. We also saw that in April 2021, the Supreme Court passed blanket directions in this entire matter of conservation of Great Indian Bustard. In its directions, the Supreme Court, in April, we're talking about the April directions. So in April, the Supreme Court imposed restrictions on setting up of overhead transmission lines in a territory of about 99,000 square kilometers in Great Indian Bustard habitat in both of these states, Rajasthan and in Gujarat. So once the April 2021 order and direction came into picture, what did this direction do? It gave blanket direction to impose restriction on setting up of these overhead transmission line in this designated area. Now, as was expected, the government came before the Supreme Court seeking modification of this direction. Why? Because essentially the government was saying that, we have certain development agendas, we have certain projects that we need to work, the renewable energy project especially, and because of this blanket directions, we are unable to process those projects. And as a result, you may kindly, modify these directions. So the Ministry of Power, that of Environment, Forest and Climate Change, the Ministry of New and Renewable Energy, they filed the application to modify the 2021 order on the grounds that it had adverse implication for India's power sector, and that the undergrounding power lines, it was not possible. So in April 2021, one of the direction given by the Supreme Court was that instead of having overhead transmission line for the new projects, we can try, undergrounding the transmission lines. So the government said that this was not possible. The three ministries also cited India's commitment on transition to non-fossil fuel energy sources under a couple of international climate instruments. What are those instruments? To give you an example, the Paris Climate Treaty. So essentially, the government was saying that, we have certain obligations whereby we've agreed that we are going to transition to we're going to transition to renewable energy resources, which are non-fossil fuel based energy resources. So if we are going to implement these directions, this is going to curtail this obligation also. So now let's see, what did the Supreme Court say? So the Apex Court modified its April 2021 order. giving blanket direction for underground high voltage and low voltage power lines, and directed experts to assess feasibility of undergrounding power lines in specific areas after considering factors like terrain, like population density and infrastructure requirements. So Supreme Court has essentially agreed with the center and has modified these blanket guidelines or directions. The ruling acknowledged that its earlier directions, besides not being feasible to implement, would also not result in achieving its purpose. What was the purpose behind these directions? The conservation of the Great Indian Bustard. And the court noted that the April 2021 order, it was not fulfilling this agenda, which is conservation of these birds. In essence, the ruling put Apex Court's stamp of approval on Union's affidavit on steps for conservation and protection of Great Indian Bustard. However, the court, apart from this acknowledgement, also made several other observations on climate change and on litigations in other jurisdictions. So, in this respect, the ruling stated, and I would like to quote that, prior to adjudicating the application for modification, it is necessary to briefly advert to India's obligation towards preventing climate change and tackling its adverse effect. This will assist the court to take a decision based upon a holistic view of competing consideration. So apart from modifying these orders, the court also made several observations with respect to climate change, with respect to human rights, and with respect to India's obligation to adhere to certain climate treaties. So, referring to environment related aspects of directive principle of state policy, the court said that these have to be read together with right to life and personal liberty under Article 21 of the Indian Constitution. The Supreme Court has so now let's see how the Supreme Court has interpreted Article 21 earlier also. In the introduction of this video, I said that the ambit of Article 21 has been expanded so many times by the Supreme Court by inducting a couple of rights under the umbrella of Article 21. So now let's see what are those rights. Let's take some examples. So Supreme Court has historically acknowledged Article 21 as the heart of the fundamental rights in the Constitution. The court has said that the right to life, it is not just mere existence, but this right to life that we have, it must include, and it does include, all rights that make it a meaningful and dignified existence for an individual. In 1980s, the Supreme Court read the right to a clean environment as part of Article 21. A bundle of rights, including right to education, right to shelter in context of slum dwellers, then right to clean air, right to livelihood in the context of hawkers, and the right to medical care. All of these have been included under the umbrella of Article 21. However, this is a reality, and that all of us, we are aware of that these new rights, they cannot immediately be materialized or exercised by a citizen. What needs to be done instead is that there must be some sort of a legislation, there must be a policy decision on part of the state. Then only these rights will in essence be implemented. So that said, their express recognition in the fundamental, however, is helpful in two aspects. So what are those aspects? First is whenever a right is given the status of a fundamental right, then it is a nudge to the parliament to take note of these issues. And second, by making constitutional courts an avenue for citizens to litigate these issues in future. Why? Because it is a fundamental right, and therefore constitutional remedies in form of Article 36, 32, and 226, all of these can be resorted to approach the constitutional courts, that is to say high courts or Supreme Court, for litigating these issues. Now let's see, while dwelling on India's international commitments to mitigate the impact of greenhouse gas emissions, the Apex Court also noted that despite many regulations and policies to address the adverse effect of climate change, there was no single legislation related to climate change and to attendant concerns. However, the absence of such legislation, the bench said, it did not mean that Indians do not have a right against adverse effect of climate change. So this is the observation which is very, very important. The Supreme Court said, even if there is absence of legislation in this regard, that also does not mean that that Indians, they do not have a right against adverse effects of climate change. We do have a right. What are the implications of the judgment for environmental jurisprudence? Environmental lawyer Ritvik Datta, he has said that the Apex Court's judgment, it puts the focus on strengthening environmental and climate justice by elucidating the multiple impacts of climate change on a range of communities. In this regard, Datta said, and I would like to quote, the significant aspect of the judgment is the expansion of Article 14, because we've seen, on earlier occasions also that Article 21 has been expanded. But here, Article 14 has also been, given an expansive interpretation. So over the last few decades, the right to life has been expanded by the Apex Court to include a right to clean environment. The judgment not only looks to curb environmental pollution, but also proactively outlines environmental and climate justice issues, keeping our international commitments in mind. Then we have another opinion by the lead for climate and ecosystems at Vidhi Center for Legal Policy. He has said that this judgment will set an important legal precedent and it is going to influence the broader public discourse on environmental matters, and it has the potential to shape future government policies. He said that the Supreme Court has on several occasions in the past decades relied on the Constitution to uphold human rights pertaining to environmental issues. This includes rights such as the right to live in a healthy environment, right to enjoy pollution-free water and air, right to live in a pollution-free environment, and all of these. Typically, such recognitions, it signify issues of broader public interest where existing laws and policies are inadequate. The acknowledgement of the right against adverse effect of climate change by the highest court, it establishes a significant legal precedent. I hope this article is, helpful. And now we proceed to the next segment for today. So now we proceed to the national news category for today, and this is the first update. India's plan to end urea imports by 2025. India aims to halt urea imports by the end of 2025 by boosting domestic production and promoting alternative fertilizers. This is in response to the nation's significant reliance on imports, which currently satisfy around 30% of its annual urea demands. So there is a push for domestic production of urea and curtailing the imports. Now let's talk about what are some of measures or efforts to halt the production of urea, to halt the import of urea. I'm sorry. So this is increasing domestic production, reviving closed fertilizer plants. Then there's promotion of alternative fertilizers like nano liquid urea and nano liquid DAP. Then there is initiative like PM program for restoration, awareness, nourishment, and amelioration of Mother Earth to promote alternative fertilizers and balanced fertilizer uses, and there's subsidy on fertilizers. So these are some of the efforts that have been taken to curtail imports and revive or to increase and largely based on domestic production. Next is Bilquis, the first Indian woman on the Paris Olympics jury. Bilquis, a canoeist from Jammu and Kashmir, she is set to make history as the first woman from India to represent the country as a jury member at the upcoming Summer Olympics in Paris. Next up is an update in the defense category. Navy Chief awards unit citation to INS Sharda for anti-piracy operations. Admiral R. Hari Kumar, the Chief of Naval Staff. You may also, take a note of this name. Admiral R. Hari Kumar, Chief of Naval Staff. He's been awarded on-the-spot unit citation. He has awarded on-the-spot unit citation to INS Sharda for successful conduct of anti-piracy operations during his recent visits to Southern Naval Command, Kochi. The ship, it was involved in the safe release of all 19 crew members of Iranian fishing vessel, which is named Omari, which was held hostage by pirates off the coast of Somali. And out of these 19 crew members, 8 were Pakistani and 11 were Iranian. Peter Pellegrini, he's been elected Slovak president. In Slovakia's recent election, presidential election, Peter Pellegrini, he has emerged victorious, reinforcing the pro-Russian stance of the Prime Minister for the country. So next up, we have an update in the sports category internationally. Extreme marathon runner Russ Hook, he has completed his run across entire length of Africa and arrived in Tunisia. He traveled through 16 countries within a span of 352 days. The 27-year-old, he passed through all of these countries largely, Namibia, Angola, Democratic Republic of Congo, then we have Nigeria, Cameroon, then Ivory Coast, Senegal, before he arrived in the city, which is a part of Tunisia. Moving on to the next update. Now we come to the legal news for the day, and we first have a Supreme Court verdict, which is essentially the case that we discuss in the editorial. So for the first, Supreme Court recognizes the right to free from adverse effect of climate change. In its first, the Supreme Court, through its judgment, has recognized a right to be free from the adverse effects of climate change as a distinct right. The court said that Article 14, what does Article 14 provide for? It is equality before law and equal protection of laws. So the court said that Article 14 and Article 21, right to life and personal liberty, they are important sources of this particular right. The court in this regard said, and I would like to quote, the right to equality under Article 14 and the right to life under Article 21, it must be appreciated in the context of the decisions of this court, the actions and the commitments of the state on the national and international level, and the scientific consensus on climate change and its adverse effects. From this, it emerges that there is a right to be free from the adverse effect of climate change. It is important to note that while giving effect to this right, courts must be alive to other rights of affected communities, such as, their right against displacement and allied rights. This observation, it is a part of the same decision where the three-judge bench constituted an expert committee to examine the scope and the feasibility and the extent of installing overhead and underground power lines in areas which are considered priority and crucial for the conservation of Great Indian Bustard. All of this we've extensively already covered. The name of this particular matter is M.K. Ranjit Singh and others versus Union of India and others. You may make a note of this case law's name as well, just in case it may feature in the PT portion of your exam, the prelims. Another update is also from the Supreme Court. The Supreme Court has recently, in the case of Annapurna B. Upin and others versus Malsidappa and another, has held that the legal heirs of a deceased partner do not become liable for any liability of the firm upon the death of the partner. The bench further stated that the liability of the deceased partner does not pass on to its legal heirs. So that's about the TNA that we have for today. In case you happen to have any queries, you may get in touch with LawSikho using these points of contacts. These are, and also in case you want to get access to the free study materials or the TNS slides that have been used in this video, I would highly encourage all of you to join our Telegram channel. And for doing so, you may scan the barcode here or click on the link which is given in the description. Thank you for being with us. Have a wonderful day ahead.